So with no further ado, this is a power hour, and let's not lose any more minutes. I'd like to welcome to the meeting Natalie Salkeld, who is the Business Engagement Officer at the Intellectual Property Office. Welcome, Natalie. And you've taken control.
Hopefully, yeah.
Over to you.
Hello, my name's Natalie. I'm one of the business engagement officers, like you said. So I go to business events all over the UK, giving an overview of IP. So I'm going to give you a brief-ish overview of IP and then hand over to Jerry for all the technical stuff. So as you know, the Intellectual Property Office is the official government body for protecting property rights within. Can everybody turn their microphone off because I'm having a lot of echo? Sorry, thank you. Because I can hear myself about 1,000 times, which is really off-putting, sorry. Yeah, so we're the government department that deals with all the intellectual property rights, which is patents, designs and trademarks we register, and copyright is an automatic right, but we'll go into that later on. So we're going to start with trademarks. Sorry, my slides have been mixed up. So what is intellectual property? It's a collective term for creations of the mind, and it is the fixed formats that they're in. When it's an idea in your head, we can't protect it, but as soon as it's in a fixed format, we can protect it. So we're going to go over all the rights, trademarks, patents, registered designs, copyrights. We'll go into some unregistered design rights, and I'll go over a bit of trade secrets and confidentiality while I'm at it as well. So trademark. So this picture has got a very interesting reason to be linked to copyright. And I'll go on to the next page to show you what it is. So if you look in the corner by there, it's a Bass bottle of beer. And Bass was the very first trademark ever filed in the UK. So it is trademark 00001 and it's renewed every year. Unlike other other IP rights, trademarks can be renewed indefinitely. So this one's been going since 1876 and is still going strong. So what are trademarks? It's any sign that's capable of being represented graphically. So if you look at all the boxes on the side, all these companies have protected their logos and their names. They built up a reputation. And you know that if you have a glass with Carlsberg on it, it's not going to have a soft drink in it, and vice versa with Coca-Cola. And they've built up a reputation and they are proud of their name. It's got to be capable of distinguishing one goods and services from another. It can be renewed indefinitely, unlike the other IP rights, and you can only use an R in a circle if you register with us. You can use a TM after your name, and that's unregistered trademark, but the onus is more on you with that to prove that somebody's using your trademark. Apologies. So what can be registered? All these here, so names, logos, domain names, slogans, color themes, shape themes, actions and music. So if you look at these, that particular Pantone of orange for EasyJet, that's been protected by them, so it can't be used in commercial purposes. With the Toblerone, that shape has been protected as well. What you'll find is a lot of companies might protect a design and trademark it as well, because a trademark is indefinite where a registered design only lasts 25 years. The Asda action of tap in the pocket has been protected, and music can be protected. Nike, the logo, you don't need the name on it. If you see the swoosh or the tick, then you know that's Nike. So they can all be protected, but it must be distinctive from the goods and services they provide. So I always use the example, I've got Apple's okay for a watch or a phone, but you wouldn't be able to call yourself Apple if you were a greengrocer, because it describes the goods and services you provide. So it has to be distinctive. So what can't be registered? It can't be offensive. Like I said, it can't be descriptive. and it can't use laudatory terminology like the best a man can get. Gillette use it, prove it. Wilkinson Sword or another company might think they're the best razor. So you have to have receipts, or you have to have proof that people automatically will link that logo or anything like that, or that slogan with you. You can't use protected emblems. So anything like the Red Cross, International Red Cross, the Olympic rings, flags, I couldn't think of the word then, and royal emblems, you can't use anything like that. That they're protected emblems, and we have got all the information on them on our website. So just to break it up a bit, because it's all going to be quite technical, I'm going to go through these. This is just to show you how slogans as a registered trademark, why people protect their slogans, because if you say these things, you automatically think of the company. So just the power of a slogan. So it does exactly what it says on the tin. Can anybody type that one out or call that one out?
That's Ron Seal, isn't it?
Yes, well done. Good things come to those who wait.
Guinness.
Well done. It's good to talk. That's an old one, isn't it?
That's BT.
BT.
Yeah. How do you eat yours?
Have a cream egg.
Yeah, well done. Buy it, sell it, love it.
eBay.
Yep. I'm terrible with this. Voorsprong durch Techniek.
Audi. Audi.
Well done. Why have cotton when you can have silk? I didn't know this one. These are new ones. We had, so I'll share this one. It's Galaxy. The world's local bank.
HSBC.
Yep. Once you pop, you can't stop.
Pringles.
Pringles.
Yep. And impossible is nothing. A lot of people don't get this one as well. I wasn't 100% sure. It's Adidas or Adidas, depending on your age. So with trademarks, we have got a trademark register that's free to look at. What we do advise you to do is, before you register your trademark, to have a look on our trademark register to see if it already exists, or if it already somebody's already using it, just to save yourself, making sure you avoid expensive mistakes, like you could get your website all set up and sweatshirts printed, t-shirts printed, a load of things with logos on, and then you can't use it because it's already in use. It makes you appear aware of competing marks, so you can come to some arrangement with the person, if you wanted to, who had the trademark. So that would give you early resolution of problems, and obviously it's free as well on our website, so you can use that. So with the UK, since we left the EU, when you register with us, you're only protected in the UK. So it's £170 for one class. There's 45 classes, and you pick what classes you want to be covered in. What we do say is, if you've got a 5-year plan where you're going to venture out into different classes, if you protect the classes that you want to venture out into now, it's only extra £50 on the £170 for each class. If you do it later on, you're going to pay £170 each time. So it's just worth knowing, if you want to cover yourself in a couple of classes, to do it at the beginning when you register originally. The EU IPO is €850. That seems quite a lot, but obviously it's covering the countries in Europe as well. So that's quite a good deal. And with WIPO, the World Intellectual Property Organization, they've got something called the Madrid Protocol. It sounds like something out of a spy movie, but all it is a calculator. You put in the countries you want to be covered in, and they will calculate a fee for you. The good thing about doing it through WIPO is they do provide a translation service. So if you were going to venture out into a country and you went directly to the country, you would have to pay for the translation, where WIPO include it in what they provide. So it's worth noting. If you do need professional legal advice, we advise you go to a trademark attorney that's part of SITMA, just because they're a chartered institute, so obviously they've gone through certain things to get on there. So we're going straight on to copyright now. So with copyright, it's an automatic right, and it's covered by the Berne Convention, which is countries have all come together, and it's a governing body concerning copyright. It's protected as soon as the work is fixed. So while it's, like I said, while it's in your head, it's not protected, but as soon as it's in a fixed format, it is. We can protect it. You may need to provide proof when the work is was created. With copyright, it's all about proving that you created a document before somebody else, or you've created something before somebody else. So what you start with and what you end with, anything creative isn't going to be the same thing. So make sure you keep every iteration of what you've done. If you've done drafts and redrafts, keep as much evidence as possible, because in the end, it's proving in a court of law that you created it before somebody else. So what is covered by copyright? All these here: books, films, music, songs and sound recordings, photographs, paintings, manuals, databases and dramatic works. What isn't protected? So it doesn't protect work already in the public domain. So the Scarlet Pimpernel and Dr. Dolittle, the people who wrote those books, have passed away in 1947, so they're out of copyright now. I couldn't go and say, oh, well, I'm going to copyright them now if they're out of copyright. Once they're out of copyright and it's expired, you can't redo it. Like I've said about 4 times, it's the expression of the idea, not the actual idea. So it's only in the fixed format that you produce it in. Single words, they can be protected, but it's extremely difficult to protect them. Titles like the Duchess of Sussex and facts can't be protected because there's no creative input into it. So how long does copyright last? So published editions is 25 years. TV and radio broadcasts are 50 years. Sound recordings are 70 years. And this is the important one: literary works, films, music, dramatic and artistic, last up to the person's death, and then 70 years after their death. So to reiterate the fact, I'm going to share, I'm the sad person that in November of every year, I check the top dead earners of whatever year it is. It's just to prove that even though people have passed away, this is how much they've just earned in 2024, their estate has earned in 2024. So I'll go through them and then I'll just give you a little overview of stuff. So 17 million is John Lennon. Then Matthew Perry, obviously because he passed away, he's in the news and everything, and he's come into the top 10. That is Charles Schultz, I think, because I get him and Dr. Seuss mixed up, but that's 30 million. Bob Marley has recently had a biography film, a biofilm done of him, so he's still in there. Prince, a lot of these you'll find a musical because their estate sells a lot of their back catalogue, so that's where the money's been made by them. That's Rick Ozarek, who was in the Cars. I only learned this year. It's just he died recently, so that's why that's in there. Elvis is in there every year. But mainly a lot of it, interesting fact, is because of Graceland, not because of his family. I mean, his daughter dying and his granddaughter being in the Daisy and the Six and things have brought him more to prominence, but it is people visiting Graceland that has brought the money up. That's Dr. Seuss. And then 250 million is Freddie Mercury, and who do you think's number 1? Any ideas?
No, Beatles.
It's Michael Jackson, because he's got a musical coming out. His nephew's playing him in a film, so there's a lot of things, and there's a Cirque du Soleil coming out as well. So his estate is making a lot of money out of that. And that's just in 2024. So it's worth knowing, just as an interesting fact. So who owns the first copy? Who first owns copyright? It's usually the first creator or the author. But as you can see here, an employer will usually own the work if it's produced in the ordinary course of employment. So with these slides, I've produced them, but because it's my job to do presentations on behalf of the IPO, Crown Copyright owns it, the IPO owns it because it's my job to do it. A contractor may retain ownership of works created, unless it all depends on what contract you have. So we advise you, if you create something for somebody else or they create something for you, ensure there's a contract in place stating who owns the copyright once it's been handed over. And you always retain moral rights even if you sell your copyright. So if you're not happy, if you're extremely unhappy with what it's being used for, you're well within your rights to say, no, you can't use it. So what if there's more than one creator? We use Harry Potter because he's absolutely everywhere. So Harry Potter was created by J.K. Rowling. There's been books, Lego, games, Primark to loads of things, bags, tops, everything. There's computer games that my children play on. In Universal, there's the Universal Harry Potter World in Universal. All these would have had to request permission off J.K. Rowling to use the Harry Potter name, and she's licensed it out to all these people for them to use. With licensing, we might not all be the next J.K. Rowling, but it is a way of making money out of things you create by licensing them out to other people to use. Also, all these people, Lego, PS4, and Primark will all have their own IP involved in all of the work they produce as well, but they will always have to license the Harry Potter name from J.K. Rowling. So there are some exceptions and permitted acts, and these are listed here. So it's private study, education, libraries, research, incidental inclusion, visual impairment, criticism and review, news reporting, parody, time shifts in broadcasts, and some official reports. I'll just go over a couple of them. Private study, you can use work as long as you let the person know, give them the credit for the work that they produced in your work. My daughter's doing her degree, and she's got to make sure that she puts everybody at work that she uses in her essays or anything like that. Visual impairment is where books are translated into Braille for the visually impaired. Parody, it's Christmas time nearly, and John Lewis will do a lovely advert, and within a week or so, Aldi's and Lidl's will do a parody of it. Incidental inclusion, all I would say is if somebody was taking a picture of me or videoing me, and then somebody's car went past with Ed Sheeran playing in the background, that's incidental inclusion, so it's not breaking any copyright. It wasn't your intention to capture that in the video. So copyright infringement, there's primary and secondary. So primary is copying and reproducing, adaptation, distribution, public performance, lending or renting and making available. And then the secondary is selling and importing, possessing for business purposes and facilitating the primary infringement. So the bottom bit says ignorance is no excuse, but you're only guilty if you infringe knowingly or you ought to have known. I'm from the Blockbuster days where you went to a video shop to get a video. I mean, it's a bit more advanced now, but if Top Gun, the first one, or even the second one was out, and you had the video the same time, you knew it was a pirate copy. It is a bit more difficult now. If it's too good to be true, then it is probably infringing on somebody's copyright, so to be very careful. So with copyright, as it's an automatic right, we say record your work, keep as much proof as possible. So everything you produce, make sure you keep it as a timeline of the creation of what you've produced. Use contracts so you know who owns the copyright if you're doing work for somebody else, or they're vice versa if they're doing it for you. And be aware of licensing opportunities for your work. If you don't want to do anything with it, you can license it out to other people. And finally, as I said, there is no official register. So there are people who will let you upload it to their site, but if you created it 6 months before that, you still need proof of that 6 months. So just be aware, if you upload it to a website, it's only from the date it was uploaded. You'll still need to keep proof. So registered designs is the next one. So with the registered design, it's how the actual product looks, just its visual appearance, nothing else. So that would be the physical shape, how it's configured, so how the different parts go together, and decoration. What it doesn't protect is how it functions, how it's manufactured, and it won't protect the design whose appearance is dictated solely by its function. So we've put 2 plugs here just to prove they have to be that shape to plug in to make something work. They can't have any different, you couldn't put the prongs in a different place because it wouldn't work. So that wouldn't be able to be protected. The same with the key. Key has to be a certain, I got to do actions. The key has to be a certain way for it to turn, to open a lock or open a door. So that wouldn't be able to be protected. You might be able to protect the fob part of it by doing a flower shape or something like that, or changing the design there, but the actual key bit you wouldn't be able to protect. So with registered designs, I'm going to go through the online prices. It's £50 per design, and then you can do up to 50 designs for £150 in one single transaction. So you could put all those designs filed at the same time, and they don't have to be related. So it doesn't have to be a collection of anything. Excuse me. Apologies for that, I had a tickle in my throat. It doesn't have to be, they don't have to be linked. They can be random designs, but they have to be filed at the same time. So if you need more advice on anything to do with design and copyright, you can contact our IP advisors. They're available 9 till 5, Monday to Friday, and they will answer the phone. It is a human being on the end of the phone. It's not a recorded message or anything like that. So it is a selling point for us that you can talk to somebody about your IP. There's also anti-copying in design, or ACID for short, and they can offer you practical advice and specialist support about your IP and help you with that. And then there's you can do what's called IPEC, which is the Intellectual Property Enterprise Court, which is like a small claims court for IP purposes. So patents is next. I'll try and be as quick as I can. So with patents, where the design was how it looked visually, patents protects the inside of it, how it works and everything like that. So a new invention, how a product works and its technical function, so what they do and how they do it. So there is a criteria for patentability. It must be new and novel. Prior disclosure of it will invalidate your application. So if it's out in the public domain, you wouldn't be able to protect it. It must be an invention or an inventive step. So I use the example of I want to say Hoover, but that's a trademark, vacuum cleaner. That's been around for years, but Dyson created an inventive step on a vacuum cleaner. So that was how he was able to protect that. But it must have a technical effect as well. So with us, the patent fees are approximately around £300 to £400 with us. But we do advise that you use a patent attorney when doing your patent, because only 2%, our records show that only 2% of people who do it themselves get through the process and get their patent granted. So we do advise using somebody who's a member of CIPA, which is the Chartered Institute of Patent Attorneys. So how long does the process take? I'm just going to show you this. It's just to prove how it is a longer process than the other two. With designs, it takes about 3 months to get your design registered, and with trademarks, it takes about 3 months as well. And 2 months of that with the trademarks is going on the register for people to see, for the public to see. So it is a quick process, where if you look at patents, you file a patent today and it might not be granted for many years, but you will have priority over it. So if anybody comes after the date that you filed, you will have priority over them. But it is more of a long-winded process and a longer process than the other two protectable rights. So as I said, patents, keep your inventions confidential, use non-disclosure and confidentiality agreements if you do have to discuss it with anybody. Search for existing and similar inventions on our search. I can't think of the name. Not Ipsum, Spasnet, sorry. Make sure you check that, because if it already exists, you might not be able to protect it. And like I said, seek the help of a patent attorney to draft your application. This is just for information. I've added it to it. I can't explain it in detail. Maybe Jerry will be able to explain it. But what it is we've got Resource Hub for standard and essential patents. And there's loads and loads of information concerning it for SMEs to use. So there's a QR code, and if you will be having the slides. It's just giving you access to those slides, that information in that hub. So I've just got two slides on IP abroad, and then I'll hand over to Jerry. So it's just to give you key messages. Know before you go, if you're protected in the UK, it might be not the same rules and regulations in another country. It's territorial, so just remember, if you're protected here, but you get things manufactured in another country, you won't be protected in that country. So just look into that. It's first to file across the world, so act early and don't assume confidentiality. So make sure you think carefully before you disclose anything. And there's a link to our non-disclosure agreements that we've got on our website. And we have got very good resources on the IPO website. We've got an international IP service that gives you guidance on how to protect everything in all, not every country in the world, but we are adding to it all the time. There's country guides that will tell you how long it takes to get a trademark and things like that, how much it's going to cost, the pitfalls, of trading in another country and things like that. We have got IP attachés all over the world, and they cover certain areas, but they're actually in the location that they are working in, so they'll be able to give you one-to-one advice and help you out. And they're the boots on the ground, so they'll know exactly what's going on in those areas. And also the DPT have an export support services, which is excellent. So we have got further resources. On our IPO website, we have got a support platform with a lot of things. There's IP Equipped, which is a 4-module course that you can do that's very light touch. You can do a health check concerning your IP on our website, and there's a lot of other information on there as well. And the QR code sends you straight to that page. This is just information. We've got a customer support center that you can email. The IP online tools that I've just showed you, the international IP service, and I'm a business engagement officer. So if you did want us to do any other events, we are available to do that. And that's me done. So I'm going to hand it over to somebody else. Or
Thank you very much.
Yeah, sorry.
Yes, thank you, Natalie. Jerry, welcome on board. And just before you make a start, if any of you have got any questions, please add them to chat. We will have time at the end, hopefully, to be able to ask questions. And if not, we will make sure that your questions get answered and we will send them out afterwards. Jerry, over to you.
Thank you very much. Thank you, Natalie. Hello, everybody. My name is Jerry. I'm a chartered patent attorney and a chartered trademark attorney, and I'm going to run you through some of the elements involved in the thinking process when it comes to engaging with the IP system. So you've heard about all the different types of IP. What I'm going to talk about is how this impacts your business and how to make decisions about what you should be doing, and how to go about doing that and what you get out of it. So just very, very quickly, this is just a slide. Again, you can have this slide deck and take this information away with you. I won't go through it, but this is just about us. We're a medium-sized firm. We've got 2 offices conveniently located around here, one in Brentford and one in Slough. We're a full spec firm, so we can do everything, patents, trademarks, designs, both here in the UK, in Europe, and anywhere else around the world through our network. This slide is basically a bit of a summary of what you've just heard, but it's coming at it a little bit differently. Very, very few people will engage with the IP system without using an attorney. Almost everybody does. So there's thousands of chartered patent attorneys in the UK and thousands of chartered trademark attorneys. And if you have any kind of IP requirements, then go and find a local one and speak to them and use them. So when it comes to patents, you really do have to have a patent attorney to draft that for you. But trademark attorneys are very experienced. They've got a lot of clients, they handle many, many brands and know all the ins and outs of all the different things you should be doing. And the only point I want to make about this particular slide is that the costs I've got on here are the costs you're looking at when you're using an attorney. So the costs you've heard about so far are the official fees that the UK IPO charges, which are in fact incredibly reasonable on a global scale. Other offices are a lot more expensive. The UK IPO is very, very cost effective. But if you're talking about patents, then it might cost you something in the region of £5,000 to get a UK patent application prepared and filed by a chartered patent attorney. And if you protect your inventions across multiple jurisdictions around the world, say China, EU, US, you might spend £20,000 on it over 4 or 5 years, just to give you a flavour of that. With trademarks, again, I've got some costs there in designs and copyright. You can come back to those and have a look. But if you had any particular requirements and you wanted to ask me about it, then you're free to do so. So my slides here today have been compressed right down from an hour-long talk, so I'm going to go through them very quickly. But what I want to talk to you about is how you engage with the IP system and what you get out of it and why you should. So what I've got is an illustrative example. So this is a made-up example of a particular business, and we're going to talk about how that business behaves and how it might do things differently. So this business imagines that it's created a new type of torch. So there's a picture of a torch. And let's imagine that it's got a new invention in it. So it's got a rechargeable power supply, which lasts longer than anybody else, and it does it in a technical way. It has a new product design, which is the aesthetic appearance that you see there. And there's a brand name which needs to be protected. So if you were already like this, if you're a business that has already created the product, already on your way, already got investment, already got your tooling set up and running and stuff like that, if you engage with the IP system at this point, then you're already at a disadvantage because you're basically going out and getting what you might be able to get. So you might file a patent application without knowing a great deal about whether it be granted or what you're going to get your patent for, because you don't know much about what's already out there. You might apply for design rights, again, without really knowing a great deal. With your trademark, you don't know what other brands are out there. So you're sort of tacking things on. And if you do that, you end up with a model that looks a bit like this, where you have your business in the middle and it's already an existing business and it is the way that it is. And you've simply added on the IP to the best that you can. Now, that's obviously a lot better than someone who doesn't engage with IP at all. Because if you don't engage with IP at all, you've got serious problems. Anyone who's in business is going to be using a trademark because you're selling products or services. So you must engage with the IP system, at least on that level. On top of that, if you don't engage with sort of patents, designs and so forth, then you're never really going to find out what other people are doing. So you could just launch merrily, your business and then find out 6 months later that someone else has got some rights that you're infringing. So it's not good. But this model here is somebody who is actually engaging, but they're only really sort of tacking on the things that they know about, and they're not really getting the best sort of protection. So what I would encourage you to do when you're thinking about IP is to ask yourself the question and be a bit more strategic about it and ask, what kind of protection do I actually want? What do I actually need? And it all starts with you. And we have to look at what your business is, what the USP of your products is. And then a particular question is, what is the main threat? What are you trying to prevent from happening? Because that's what IP is. It gives you the right to prevent other people doing things. The next question is very important, which is, what can I afford? Because it might be very cheap in terms of the fees to file a UK trademark application. But if you're looking at registering your brand across 25 countries, then you're going to spend a lot of money. And maybe you've got designs wrapped up in there. Maybe you've got some patents as well. So you've got a lot of expense that you're looking at if you're a startup business and saying, well, I'm not really sure about how I'm going to spend this money. What's the priority? You can ask, are you insulated in other ways? So we have some clients who just can't be copied because of, for example, regulatory requirements. So they don't need patents because nobody can copy them anyway. So what's the point of spending money on it? That's just one way of thinking about it. If you're looking for investment, if you're looking at exit strategies, that's going to have an impact on what kind of IP you go and get. because investors, and if you're selling to a buyer, they want to see certain sorts of things. There are also tax benefits, so maybe you go about it because you want those tax benefits. So there's a lot of questions involved in what you actually end up doing. So this is a summary slide I'm going to go through very quickly about what you actually get from areas of IP. So from a patent's point of view, you're preventing other people selling something. So what that gives you is increased sales. You sell more than you otherwise would because other people can't compete with you. It allows you to build a reputation. You can talk about the rights publicly and gain traction. You can license your IP out. You can cross-license in a situation where someone's coming after you. But importantly, there are big financial benefits through the patent box tax relief and also R&D tax credits, which I won't go into too much, but it's a way you can make a big saving on certain tax. Trademarks, again, it's about increasing your sales. It's about maintaining the exclusivity around your brand. The more distinctive and registrable and well protected your brand is, the less people can get close to you. So it increases your sales and makes you a better business. Again, protects your reputation and so forth. You can license things out. If you have good trademark registrations, it's easy to enforce them against others. If you don't have such good ones or none at all, you've got problems. With designs, it's similar. Again, it stops other people competing with you, but we'll come on to this in a minute, but it's a bit different between designs and patents. And you have to ask yourself, what is actually the most important thing for my business? From a copyright point of view, if you're a media business, then being in charge and in control of the copyright helps you to build an entire business. I mean, all media that exists, the entire media industry across the whole globe only exists because of copyright. Because if it didn't exist, anyone could just copy anything. So all films, music, books, plays, they're all built on copyright. And with regard to the kind of work that we do, as has been said already, copyright exists automatically. So you don't have to worry about doing anything to protect it. But there's an awful lot of work we do on making sure that you own it and license it properly. You can have a lot of problems if you don't get it assigned to you when you're using it, or if you're using something that you shouldn't be using. That's where a lot of copyright issues come in. So if we're being a bit more strategic, let's go back to our example of this business with the torch. We've got the same things. It's got an invention in there. It's got a new design. It's got a new brand name. But let's just say, for the sake of argument, that the main rival that this company has is a legitimate rival that sells goods that isn't likely to infringe on the IP. And you don't really need to spend a lot of money filing patent applications because there isn't a budget for it. So a decision is made not to bother with the patent. Now, that's just a strategic decision that some people might make because of commercial requirements. However, what they've done instead is focus on the design registration, because that gives you the power to stop very particular sorts of things. And what I'm talking about is counterfeit products that are sold on Amazon and eBay and Etsy and things like that. You can use design rights far more effectively on those platforms, and also with customs and excise and trading standards, than you can with patents. So if the main threat is people making counterfeit versions, designs become the priority. So in this case, illustrative example, they've chosen the designs. They also choose themselves a distinctive and registrable trademark, and I'll come on to explain what I really mean by that in a minute. So then you end up with a model that looks a bit like this. It's a bit better. You've got your business on one side. You're looking at the options in front of you of what I need to have, and you've selected the things that are going to be the priority, that are going to give you the best rights, and you end up with a stronger business as a result. In this case, trademarks and designs are all that are really needed to protect the particular product. So I just want to move on quickly to a higher level than that, where instead of asking the question, what kind of protection do I want? You might ask yourself the question, what kind of business do I actually want? Now here, somebody's thinking about IP before they even think about what their business is going to be. Now, that doesn't happen very often with an entrepreneur or a new business, where they'll come to us and of course they've already got their ideas and they know what they want to do. But it does happen a lot with our big established clients who might move into a new technical field, who look at it and go, well, I want to move into this field over here, and I want to find out what's available to me and what's, how I can build a stronger business. So they identify a potential market, they research the IP that's in that market, and then they deliberately invent and design to get better protection, which is something you can definitely do. And they choose branding to be able to protect it. So in this case, this business might, instead of just designing the torch straight away, what the first thing they would do is they would identify a business opportunity. They might go out and look at a particular market. So in this case, the torch market. They identify a gap in that market. They identify that there's a problem with rechargeable torches that are waterproof, say. They do a patent search to see what's already out there, what they need to avoid, and also to learn a lot about what other people are doing. They might research the target audience for the design. So they might say, well, we're aiming this at men aged between 30 and 40 who are of a certain wealth bracket, for instance. And that would feed back into how they actually design it. So that design it in a particular kind of way to appeal to that market. Same as true of trademarks. You can really go into a loop on trademarks and think about who am I aiming this at? You really need to target it at a particular demographic, otherwise it doesn't really work. So then they've identified the gap, they've done their patent search and so on. So they've invented the torch specifically in a way to be able to get patents, because they know what patents are out there. They know what they need to do to avoid that and to come up with something that's inventive. They design their product so it doesn't look like anybody else's in a particular kind of way to give them strong design rights. And the same with trademarks, come up with something that's going to give you broad rights. And they've secured all the copyright, anything to do with any designers and stuff like that. So then your business model starts to look like this. You have a business idea, you do your research, you then do your inventing, you do your branding, you do your designing, and you do everything else in order to give you the patents, trademarks, designs, and copyright, which then makes you a leading business. And businesses out there that are hugely successful have absolutely nailed down their IP. And it gives them all that value because it gives them the protection, which essentially gives them potential future value. And that's what investors and see and buyers who are looking for exit strategies. Let's move this forward a bit. Right, so when you're thinking about it this way, you can think about the value you get from IP in a slightly different way. And this is the really important bit, and it's a very modern way of thinking about it. But if you've got patents associated with your business and you've done it correctly, then what that basically does is it attracts investment because you've added value. So the number of people who come to me now saying that they want to engage with the IP system because they want to build value outstrips those who come to me saying, I want IP because I want to stop people, I want to protect myself. Most people are doing it because they're adding that value, and it gives you a clear exit strategy, and it also avoids conflicting rights belonging to others, which is very, very important because it gives you a smooth ride. You don't get a bumpy ride by bumping into other people. Trademarks, again, you've got to have your trademarks registered if you want investment and exit strategies and so forth. It's mandatory, basically. Designs is just like patents. It attracts investment if you've got the right sort of things. And you've got to have your copyright sorted out, otherwise people aren't really interested in you. So I'm going to go very, very fast through some real-life examples of how this kind of thinking actually works in practice. So this is a product which is made by one of our clients. You've probably seen them. They're out there everywhere. It's a folding table. So the situation here was that this company had a patent that was running out. So it was coming to the end of its 20 years, and the company was benefiting hugely from patent box tax relief. So it was the patent box tax relief is a 50% reduction in your corporate tax on revenue generated on the sales of patented products. So they're selling millions of these tables. So you can imagine, it's hundreds of thousands of pounds worth of saving every year. So this is I'm not going to explain it too much detail, but this is this slide shows you what the original patent was for, and it's something to do with the way the hinge actually works. And it's to do with preventing the different parts of the leg from being pulled too far apart from one another, because if you do that over time a lot, the table fails. So they did that in this case using a particular mechanical mechanism. So we looked at the situation and said, well, is it possible to redesign this product such that we can actually get a new patent? And you might think, well, how on earth are you going to do that? It's incredibly simple folding hinge, and we've got a solution to it. But it is actually possible to do that. In order to get a patent, you just have to have something which is new and inventive. It doesn't have to be world-breaking. It doesn't have to be good. It just has to be new and inventive. So this slide very quickly shows you what they come up with, which is a more advantageous design. It achieves the same end in that it solves the same technical problem, but it does it in a new and different way. And as a result of that, we were able to get them a patent, and now they've got patent box tax relief for another 20 years. So this just shows you how you might think to yourself, well, I've already got a product. How am I going to go backwards and patent it? It's already out there. But numerous times we've helped people to actually think about a redesign at an appropriate time and then redesign to get a patent. So it is possible to do that. This is a quick example of a client of ours that moved into a different field, and it did all the right kinds of things and ended up with very strong IP. So this is a client called Brightwell who make soap dispensers. So you've probably seen them out in the wild. They're the soap dispensers with the little blue teardrop window on the front of them. You see them everywhere. And they moved into a different field, which is industrial washing machine and laundry machine dispensing systems. So these are the sort of things you see in hotels where you've got lots of big machines and it's very wasteful kind of setup. And they came at it and said, right, we want to enter this market with a completely new system that's much better than anyone else's system. And this is what they ended up with. That's far too complicated to see on the slide, but it's basically a very well designed and very interesting new type of manifold, brilliant piece of British engineering that completely replaces what you see on the slide there. That's what the entire industry was based on, using down the right hand side of the image is a large manifold with lots of valves on it. And if you're trying to dispense 10 different types of chemicals into 12 different types of machines whenever they ask for it, you know, you're doing a lot of mechanical stuff and these things break down a lot. This setup was a completely novel way of doing it. So they knew about all the IP that was out there and they said, let's come up with something completely new. And we've got very, very good patents for that. So they've completely nailed that. And it just shows you, if you know about what's out there and you attack it with the mindset that I'm going to get patents for this, I'm going to design it in such a way that it's almost deliberately different, then you can end up with a very strong business position. This is an example of a company which employed the same mindset when it came to branding. So these guys originally came to us wanting to launch a snow sports clothing company. And the original brand name they had for it was Surface or Surf Ace, which is quite an obvious kind of laudatory type trademark. There was a massive problem with that, which is that a lot of people had already registered it in a lot of different jurisdictions around the world for clothing. So it automatically was problematic. And it's also potentially descriptive of the surface coating and things like that. So we helped them to come up with a completely new made up word for their company, which was Sophanic, which you may have come across them. They're now a well-established British brand. But that's an example of somebody saying, right, well, we need to come up with a brand name that's going to be easy to protect. So we'll come up with a nice made up word. It's very distinctive, very easy to register. And they've got that protected all over the place. And they've enforced it against a number of people who've tried to encroach on their space. This is just an example of another client of ours who made a product which is almost like a staple product, and think, well, how can you get protection here? So it's sun hats for children. So what you see there is basically a generic sun hat shape. Okay, it's got little ears on it. But all the value of this product is not the shape of the hat, it's the pattern which has been applied to it. So the lady behind this company is a good graphic designer. She's got lots of very distinctive patterns. That's one of them, the banana pattern, and that's what's making her products different. So the value in that product is to do with its design, and that's protecting the registered designs. And that gives her the power to stop anyone else stealing her sales by selling counterfeit versions of that or versions of the hat with similar designs on it. It also has a very good piece of branding, which is Little Hot Dog Watson, which is a great, distinctive piece of branding that puts them in a very strong position. Whereas they could have just sold red or blue hats and, called them British hats or something, and they wouldn't have generated that kind of IP. I've got a few more slides, but I might just skip them so that we can go straight to questions. But if you get the slide deck, then this is just some basic points about how you go about doing enforcement, which can be complex. This is just a slide about if you're going to use an attorney such as myself, about getting the most out of them. There's a lot of different attorneys like me who work at lots of different sorts of IP firms, and when you choose which firm you want to work with, just make sure it's a good match. I've got a lot of things to talk about there, but we'll just skip through that. But if you're looking at it, it's like any marketplace. There's small firms, big firms, whatever. Don't use a huge law firm if you're a little company, because they'll charge you lots and lots of money and you won't really be getting value for money. If you're a very small company, you can find one-man band patent attorneys about the place who are much cheaper. This is just to say that at our firm, one of the things that we're really pushing at the moment is something we call the IP roadmap. So this is something where we go to a business and we start thinking about the IP and what's the best route forward. Not just, well, you should do this, or, you want to file a trademark, I'll just do it. It's all about reviewing your business, establishing a base camp of where you are, and then working out what the staging posts are going to be for your plan, making sure we add value all along. And the wider picture is that it should be part of your entire business development plan. And the map is very adaptable in terms of what you choose to do, but it would also include things like a 5-year spreadsheet of costs, so you can work out where your costs are going to be year 1, year 2, year 3, depending on what you wanted to do. So the final slide for me is just our details there, and anybody on this call perfectly would love to speak to any of you if you've got any IP issues. We do offer an hour's free consultation to all new clients, including BBF members. So yeah, if you want to talk about any of this stuff in more detail or any of your specific requirements, I'll be very, very pleased to speak to you. But I'll end there so we can try and squeeze a few more questions in.
Jerry and Natalie, thank you both very much for a very quick canter through all things IP.